go ahead and call this work session to order on AlaskaSense retail license number 10254. And actually for this one, because there are quite a few folks in the room, maybe we should use microphones. Aha. All right, so let's go ahead and do introductions. We'll start on this side with you, Mr. Gates.
Dean Gates, City Council.
Crystal Kennedy.
Brett Dyson. Cameron Perez-Verdia. Forrest Dunbar.
Austin Davidson.
Lee Peterson.
Suzanne LaFrance.
Felix Rivera.
Christopher Thompson.
Meg Dalzell.
John Weddleton. Ryan Yale, Planning Department.
Michelle McNulty, Planning Department.
Dave Whitfield, Planning Department.
Mandy Honest, Clerk's Office.
Ryan Stewart, Assistant Municipal Attorney.
Okay, so I just have a quick script here to read to set the frame, and then I'll turn it over to Mr. Gates to see if he has anything else to add. So assembly work sessions are held so that assembly members may gather information and discuss a topic. Today, the members will be discussing the proposed new retail marijuana establishment for AlaskaSense LLC in the downtown area on 4th Avenue. The information gathered is to help the members and the body as a whole understand the facts of this matter and identify factual issues or disputes. This will aid their decision Tuesday night whether this proposed establishment fulfills all requirements in AMC 10.80 for the license and AMC 21.50.020 for the conditional use permit. There is no time slated today for public comment or presentation by parties. However, members may ask questions to gather information. There will be no debate between the members or decisions made at this work session. This work session is to also gather information regarding current processes or legal rules and precedents for variances, information regarding protected uses, and other specific topics related to this application. If anyone in the audience would like to provide public comment, you may send it to the clerk's office. You may also attend the assembly meeting on the 22nd and provide comment at the public hearing for this proposed application. Assembly Council has provided a memo, which is in the handout packet, that outlines the process for the public hearing and presentations of staff and the parties on the 22nd. And for folks who are wondering why we're doing this a little bit more formally, I would suggest reading the memo. Mr. Gates, did you have anything else to add?
No, but yeah.
Thank you. Okay, with that, who wants to start? Well, so did we want to go ahead and just do an overview of the contents that we have before us?
Actually, point out. So,
Yes, Mr. Watson.
Typically, when we review, you want to start from scratch. That was me. That was Felix.
It's not this.
I think Mandy would go through the licensing, then staff, in this case Ryan, would go through special land
Okay.
permit thing. Do you want to kind of repeat that style?
Let's start that. Let's repeat that style, then we'll ask questions if we have any.
So, for the license review of this application, the clerk's office sends out requests to different departments to gather information on their specific areas. Okay, let's turn that one off. So in the review, all of the general licensing restrictions were addressed in their operating plan. There weren't any taxes, fees, or fines found due by any of the licensees or affiliates. All of their safety and security requirements were also addressed in the operating plan. We didn't receive any additional comments from the Department of Health. Their operating plan, their site plan was approved, but they'll have to do their inspections before they get their permits. And then all of the retail specific license requirements were also addressed in their operating plan.
So thank you, Mr. Chair. So before the Assembly is a request for a conditional use permit for a marijuana retail sales establishment to be located downtown in the B2B district. The site is located on East 4th Avenue, northeast of the intersection of Barrow Street and East 4th Avenue. The applicant is requesting 1,585 square feet of space to be licensed for marijuana retail. And the hours of operation listed in the application state that the business plans to be open Monday through Sunday between 8 a.m. until midnight. The proposed establishment does not meet the required separation distance to a nearby religious assembly, which is Hope Church. Thus, a variance request to encroach within the required 200-foot separation buffer as required by Municipal Code Title 21, Section 50, Chapter 50, subsection 420C1A, accompanies this conditional use permit application. After review of the application, the planning department finds the standards B and C of the conditional use permit for marijuana, as well as variance standards B and E are not met. Therefore, staff recommends denial of this conditional use permit with variance. However, if after a public hearing the assembly finds that all standards are met, then the approval shall be subject to the following conditions stated in the staff report.
Okay, so did you want to kick this off? So get background from other members? Yeah.
Kick it off. I probably could highlight what I see as key issues.
Sure.
Is that appropriate?
That's a good. Yeah, let's do that. Let's highlight key issues because I think that's what we're here to deliberate.
I wonder if it's proper for me to do that, though.
Sure.
I have a substantive question, based on what Mr. Gale said. What are the, I don't have the code in front of me, can you list out the two various criteria not met that you referenced? I didn't see them in here, but, and I have reviewed this comprehensively, but.
And then I guess while we're looking for that, Mr. Gates, do you want to go ahead lay the frame here for us?
Thanks, Mr. Chair.
I hope I can use this mic. All right. I wanted to mention that we have the staff report to analysis and the staff's findings and grounds for recommending denial. And I guess it's important to understand the assembly could decide differently than staff did. But if you do decide differently, you need to base your reasoning and decision on substantial evidence in the record in this matter. So if there isn't any, you shouldn't decide something differently. You would want to develop evidence, maybe some that hasn't been presented yet. That would be grounds you decide differently than the staff has decided in the recommendation. And that's important. This is appeal to the court. They look for substantial evidence in the record here.
And then there was another question from some of the members on what we can or can't discuss here today, what we can or can't ask.
You can ask questions all you want, but you shouldn't debate among yourselves about this fact or not, true or not. You can ask questions of staff and witnesses and presenters here.
Mr. Wells.
Okay, so I mean, I don't know that it'd be appropriate for me to say these are what I think are key issues in presenting that to everyone, because I think you can read the packet and gain the information. But I do have some questions on my own.
Sure.
I say, okay, look for answer because they're relevant. I think that might be better.
John, can you use the microphone?
Okay, so I'm going to ask some questions then. I think just work it that way.
Yeah.
And this would be to whoever can answer, and probably Ryan. But
Can I get answers to my questions first? I think they're ready.
oh, I'm sorry. No, that's fine.
Yeah, so I had asked staff what the two criteria what were the criteria that weren't met for the variance.
That might-
Through the chair, Ms. Salatal, so that would be standard B of the conditional use permit, and that is conforms to the standards for that use in this title and regulations promulgated under this title. And then B standard C is also not met, and that is will be compatible with existing and planned land uses in the surrounding neighborhood and with the intent of its use district.
Is that in our packet here? Or in
Yeah.
the main
Is there-
packet?
No.
That's in the main packet.
And for the variance standards that are not met, that would be variance standard B. Granting the variance will not be detrimental to the public welfare or injurious to other property in the area. As well as standard E is not met, which is the hardship is not self-imposed. Special conditions and circumstances do not result from the actions of the applicant, and such conditions and circumstances do not merely constitute inconvenience or an undesirable financial burden.
Thank you.
Mr. Weddleton?
I think one of the, we have that they do not meet the 200-foot separation. Now, that had a trigger date. Any license that was initiated before January 1 of 17 did not apply to. So the question is define initiated, because they had started some of their looking around for a building, they even rented the space prior to that date. But our definition of initiated is different. And I think that's a very important distinction. Does that 200 feet apply or not? And I got a second question. Are you going to do that first?
So through the chair, Mr. Wellington, the initiation date, so there is a requirement that the applicant notify the local governing body when they initiate the application for marijuana. The clerk's office did receive that on February 7th, 2017, and then as stated in the staff packet, the planning department became aware of that application February 8th, 2017, and a copy of that notice is provided to you in the supplemental packet provided to you today on page 13, 14, and 15.
Mr. Chair, should we be careful to have people identify their names when they speak?
Sure, we can do that.
I just wonder if the record of this will ever, our meeting will ever show up at a challenge or.
Yeah, thank you. So let's go ahead and make sure for members and others, just state your name before you speak.
Can I follow up on that?
That was
Sure.
good, guys.
That was Fred guys.
John Weddleton, so I'd like to, do we have in code or in policy somewhere clearly written when initiation is, how we define that?
Through the chair, this is Brian Yell. We don't have a definition for initiated, how it's typically referred to in code for other land use entitlements is an application submitted to the director. However, in the marijuana regulations, the language used is initiated a state application. So in this instance, we are applying when they've initiated a state application.
Okay. So that is the way we phrase it then, initiated a state application. That's initiation. In the code or in practice?
Through the chair, so the actual code citation, stand by. So the actual code language is applicants who have initiated a state of Alaska marijuana license on or before January 1st, 2017 are exempt from this provision.
Okay, that's important. Okay, can I ask one more?
Sure.
For now. All right, Weddleton again. Okay, so the second key point on this is when was there a religious assembly or church within 200 feet? And it wasn't discovered till fairly late in the process. Does that affect the fact that there was a religious assembly within those 200?
Through the chairs, this is Ryan Yell. The business license that was issued to Hope Church was issued on July 12, 2016. Churches under old code are permitted by right within the B2B district. There's no special land use entitlement that they have to get from the planning department. So in order to set dates to when that church actually became established, going on when the business license was issued, it's a solid date in our opinion. And so that would be July 12, 2016, when we would consider that church to be established at this site.
I do have one more.
Sure.
Okay.
Go ahead.
Okay, so then following on that, we have the notion of a primary use. does a church or religious assembly have to be a primary use? It doesn't make sense to say there's more than one primary use. Locally, that doesn't make sense, because a road plan does it.
So a church or religious assembly would have to be the primary use, and in the planning world, yes, you can absolutely have multiple primary uses on one site.
Thank you. Mr. Peterson.
Thank you, Mr. Chairman. I'm looking at an email that Ms. McNulty sent on May 31st, 2019. It's on page 21 and 22. And she's talking about the zoning of the property. It's in an area that's zoned B2C. And she mentions that typically homeless shelters are not allowed in that particular zoning area. And I believe that typically for a homeless shelter, it has to be in PLI zoning. Is that correct?
That's correct. That's the only zoning district that homeless shelter is allowed in.
Right. So this has been operating for several years. For quite a while, I've been informed. And so, how did it get started being in an area that was not zoned for what they were doing? Does anyone know?
We can't say. They came in as a social service. We don't know when they expanded their services to include overnight shelter.
Could you say your name for the record, please?
This is Michelle McNulty. Looking at their building permit, they came in as a social service. We have no way of knowing when they expanded their service to include overnight shelter.
Okay, thank you.
Mr. Gates?
Thank you. I can't say for certain. I think that the Department of Health or Health Department would be useful in terms of that question. I think that the Downtown Hope Center operated as an emergency overnight shelter. One of the exemptions provided in the cold weather plan in Chapter 16, 120 of our code. So, but we would want the Health Department to verify that. I agree that that's how they started providing homeless shelter services.
Thank you. Mr. Constant.
Thank you. I would argue right now that for the purposes of the code as it stands, they continue to operate as an emergency overflow shelter. They're not designated as a shelter under the Title 21 rules, because that would be the taking of rights of other neighbors around there. And so, but that isn't the question before us. And I would agree with Mr. Gates that the time that started was when the cold weather plan was implemented, when they committed to provide these services.
Thank you. Mr. Dyson.
Yeah. So I'm familiar with the whole soup kitchen thing. It's been around for decades, kind of operating in an alley and doing kind of marvelous things. Dyson. And they got the property, and I think our U.S. Senator played a part in that. And so they went on with the food service and then started a couple training programs, bakery and something else and so on. My sense is that they did start, and then as an ancillary to that ministry or service, there was a church service going on there that apparently has been documented. And I think that they got into the overflow shelter based on the needs of abused women who were scared and the need. And I think they drifted in. My guess is it wasn't a part of their original plan to do that. It was kind of emergency service. And I believe there has been a process that the city has approved of them being a shelter during the very overflow shelter in very cold weather. Thank you.
Thank you. Mr. Gates?
I understand the question as to planning. How did they start operating as a homeless shelter? And they don't know, but we do have representatives from Hope Downtown Center here. That would seem an appropriate question for them and their perception of how they started operating that way.
Does someone from Hope want to respond?
Director.
Sure.
I'm Sherry Laurie, the Executive Director of Downtown Hope Center. We started the overflow shelter on December 1st of 2015 because of a need in the city. We were approached by Brother Francis Shelter and some other members of the community, and it was discussed here. The mayor was there the opening night. It was really because of a need. It was during the whole spice epidemic that was going on downtown, and beans had become an overflow, and they asked us if we would do the same type of overflow as beans. At the end of that season, we actually thought that we would end the shelter, but the need was still there, so they asked us to continue it. And so I know there was a lot of different assembly members at the time, but they asked us to continue the shelter. And so we have for almost 4 years now. And yeah, we just had this discussion a couple weeks ago, so.
Thank you. I think I might have a couple more specific questions for you. Mr. Constant.
Thank you. Ms. Laurie, you emailed us a letter today. Would you just describe to us what you mean by this?
I'd like to read the letter. Mr. Chairman and Assembly members, the Downtown Hope Center is very appreciative of the efforts you put forward providing leadership for our city. Thank you for working diligently on representing the complex and broad citizenship of this municipality. Since 2016, the Downtown Hope Center has expressed its concern regarding the expansion of the marijuana retail stores in the downtown district. We are concerned that those we serve will be negatively impacted by the establishments. In recent years, the Hope Center has protested the efforts to open another store within our legal boundaries. We remain opposed to continued expansion of the marijuana industry in the heart of the city, but we also recognize that a collaborative effort between all citizenry is necessary to find solutions to the homeless, drug, and alcohol issues in Anchorage. Considering that, the Board of Downtown Hope Center has unanimously agreed to cease resistance of the variance AlaskaSense LLC has submitted for approval. Instead, the Hope Center will honor the determination of the Assembly and others tasked with the responsibility of ruling on their request. The Hope Center's prayer is that Anchorage would be known as a safe and prosperous city. We look forward to collaborative efforts to make this happen. With all due respect, the Downtown Hope Center Board of Directors.
Okay, thank you. Mr. Dunbar.
Yeah, I was, I'm sort of speechless by what just occurred. That's remarkable. It almost sounds like there's been some kind of agreement or discussion that's happened outside of this forum. Are we allowed to discuss that or not?
I'm not a lawyer. Mr. Gates?
I'm not clear on the question exactly. If we can discuss what? Disagreement of the letter?
Okay. I mean, it seems like they have reversed their position from this letter. Is that the case? And if so, why?
Well, the discussion is about the church. That's separate from the Downtown Hope Center. Although the pastor of the church is on our board of directors. So this letter is saying that we want what's best for the city, and we trust you as a governing body to determine what is best for the city. We've said our piece. We basically said how we feel about it, but we also don't want disunity in downtown. So that's Downtown Hope Center Board of Directors stance. Hope Church, he's not here today. He had to be out of town, so that's another story.
Thank you. Okay, well, can I ask you my actual question? So, Mr. Staff.
I want Mr. Gates to weigh in just in case we're in territory.
If you don't mind, Mr. Chair, through you on our behalf, could I ask Ms. Laurie some questions related to the letter? I think that will satisfy us. So, Mr. Dunbar's
Do you have a
concerns.
question on the letter?
I'm curious to see what Mr. Gates
Sure.
can do.
Go ahead.
Ms. Laurie, I would like to know the board of the Downtown Hope Center, it's not the same as the board for Hope Church. They're two different entities.
Exactly.
Is that correct?
Yes, correct.
So, is Hope Center authorized to speak on behalf of Hope Church?
I'm not speaking on behalf of Hope Church. I'm speaking on behalf of Hope Center, but the pastor of Hope's Church is on the board of directors for Downtown Hope Center.
And may I ask you, this part that says cease resistance at the variance, is that the same as saying Hope Church is no longer asserting that they're a religious assembly?
No,
They're still saying they're a religious
They're
assembly?
still there, yeah. They will.
Okay. And if I may, Mr. Chair, may I ask the planning department a question? Is the intent of Hope Church or Hope Downtown Centre, is that, I guess, relevant to the factors you look at when you determine the variance standards or the conditional use permit standards? Could be a little relevant or a lot relevant, just relevance.
Through the chair, Mr. Gates, Ryan Young. Their opposition or support of this really is irrelevant to our analysis of this case because the church is still there. Just because they may have a particular stance on the issue doesn't make the church go away.
Thank you.
So can I ask my actual question?
Sure, go ahead.
So on page 9 of the staff report, when you're talking about the factors to grant the variance, B is the standard that is not met, and to me that seems like sort of the crux of the matter. I guess E is something else as well, but B, granting the variance will not be detrimental to public welfare or injurious to other parties in the area. But there's really you don't provide any evidence. What you say is, it is impossible for the planning department to conclusively say that the approval of this variance will be without negative consequences to other property in the area. That to me is like, it's impossible to determine there will not be any harm to property in the area. That seems like an incredibly broad statement. So how could we ever grant a variance if that was the case? I mean, so for example, we granted a variance on Diarman Road, Upper Diarman, and perhaps it was a different set of criteria, but I think it was the same or a similar set of criteria. Did we conclusively say that granting that variance, or I guess it was a rezone, was a little bit different? Okay. So, but when we make those kind of decisions, how can we know that there's going to be no harm at all to any of the property members? That seems like a standard that makes a variance essentially impossible. Because it's a dog that didn't bark, right? You just never know. You never know if the dog's going to bark or not. You never know if there's going to be any kind of harm from any kind of variance, right? What's that?
Through the chair, Mr. Dunbar, this is Ryan Yelp. So certainly this standard is quite a difficult one to meet, or can be quite a difficult one to meet. However, the arguments presented to us in the application were not compelling enough to state the evidence that this standard is substantially met. And also the planning department cannot say, and you as the assembly know this, can't make everybody happy. So there's always going to be somebody who's claiming some type of particularly adverse impact on them by some type of land use entitlement. So I will agree with you that this does seem like a very difficult standard to meet, but we do not see sufficient evidence to support that this standard was met in the application.
So can I ask one quick follow-up to that, Mr. Chair? So for Mr. Gates, I believe we need to have some kind of evidentiary finding, right? If we do decide to go down this path, is that correct? So do we need to make some, if we were to grant a variance, we'd have to disagree with planning here and then present some evidence that will not be detrimental to the public welfare or injurious to other property in the area. And I guess I'm hung up a little bit on how that kind of evidence could ever exist. How could I find evidence that something will never harm other property at any point in the future? What would that evidence look like?
It's sort of a mixed question of interpreting what interest to the property in the area means, as well as evidence that it wouldn't be. And I think that you could find evidence, for example, in the operating plan and the application for the variance in the packet, and I wrote a few pages, I believe in there somewhere, but it might be best to even ask, I guess, for today's purposes, representatives from AlaskaSense, what was in their application for the variance that would show it was of interest to the detriment of the public welfare or interest to other property in the area. I believe the application did have some points about how it wouldn't be because of what they put in their operating plan. Perhaps we could ask a representative from AlaskaSense.
Sure, go ahead. And then before you go, so the folks I have in the queue are Dyson, Zalato, Weddleton, and Quinn Davidson. So if anyone else wants to get added, just let me know.
Take me off.
Okay. Go ahead.
Thank you, Janet Lutstein, attorney for AlaskaSense. We've also prepared a packet of information, and I don't know if this is the appropriate time for us to distribute it. I would like to distribute it. I don't have to go through it right now, but I would like you to have it and digest it over the next weekend before Tuesday. Can I have my staff start doing that through the chair?
Unless I hear otherwise from the lawyers, yeah, sure.
Okay, go ahead, Amy. In the variance application, we went through the security requirements that are required for the establishment. So that's exterior lighting, it's alarms on each door, each window, it's cameras that function 40 days, 24 hours a day. We also said that we were going to do loitering plans. So that means 2 people from the shop would come out every hour, a little bit off on schedule though, so people can't, anticipate their arrival. Circle around the building, circle through the alleyway, make sure there's nothing interesting going on that shouldn't be going on. We provided that into there. We also provided there was going to be a doorman for security purposes that should limit the impact on any negative impact on other businesses. We've also went to the Hope Center and met with their leadership and discussed how we would have one person every day go over and kind of do trash duty, circle out around the areas. So there's an empty parking lot nearby that has a lot of trash issues, and so we said that we would participate in that effort to help clean up the area. We also explained how we're not detrimental to other uses because it's proven throughout the city. Marijuana establishments have only improved areas. They haven't had a negative impact. The property values that the Anchorage Assessor's Office assesses on these buildings with licenses in them have increased sometimes 100%, sometimes more. So the property values are going up unquestionably going up. The industry has shown it's taking crack houses and turned them into establishments, and there were examples of that in the variance packet and in the application itself. And then within the application itself also talked about how there were standards and procedures of inventory control, tracking product. Every single product has an identification tag on it, so if it does end up at the Hope Center, they'll be able to bring it to us and we'll say that's one of ours, and we can track it in a point of sale system and locate the time it was bought, who it was bought by, so that we can identify people that are bringing products over to the Hope Center that may be causing them issues. So I do believe that we address those issues. It is impossible to prove a negative. It is impossible to say something won't happen or someone won't feel something. There's no way I can meet that standard. There's no way any of us in this room or any of us in the city can meet that standard. That's impossible. You're not going to make everybody happy, that's true. But we do believe, and we had a very good, and we got to know the Hope Center people, and we had a very good dialogue with them, and Sylvia and Russ from the Downtown Community Council facilitated really, really great and really inspiring mediations where we kind of hashed out a lot of stuff and a lot of concerns. And I know that the Hope Center still is uncomfortable with it, and I respect that. But the point is to give it a chance to show it's a negative impact. Don't assume it's a negative impact just because we haven't addressed every single possible thing that could go wrong. Because I can't. It's not a fair standard.
Thank you. All right, Ms. Salazar.
Thank you. I need to make sure I have Dean's attention.
So for me, this isn't about the variance. I think there's a much more primary issue in whether or not the Hope Church is a religious assembly and when that was established. And I guess I need guidance. Actually, I would refer my colleagues to Russ from the Downtown Community Council's note he sent. I really appreciated that analysis that we need to take a step back from the variance. And then, is this a question of, when do we determine the primary use? Because I don't think that's 100% clear in code. And then the question I have is, do you have to have a location before applying for a license with the state? Because if we look at the timelines, the alleged religious assembly had knowledge before the lease was signed of the potentiality of this business moving in. So I'm really stuck on the planning department's determination that this was a religious assembly, and what's that timeline, and to what extent we have authority to agree or disagree with that use determination.
The last part was the question. No, council, like, can we disagree?
Okay.
If so, to what extent?
First, there's a lot of issues in this matter, and I think that the variance is only there if the separation distance from which assembly applies, because that's what they're asking for variance for. So to write the threshold question, is there a religious assembly primary use? That's personal. I think 55 feet from the applicant's side. So that's a threshold issue for the variance elements. And of course, timing correctly if you demonstrated something wrong about how that works. And the other question has if you have authority to disagree with the planning's interpretation of that. I believe you do. You are the decision-making body in this matter. Planning makes their recommendations, but you disagree. You should probably explain why on the record. And you can do that in our documentation in the resolution if you wanted to.
Can I ask a quick follow-up?
Sure.
If we disagree, what's the legal threshold or legal standard that we need to show to overcome planning's determination, or is there no guidance on that?
I need to think about that one a little bit. Generally, planning has expertise in interpreting Title 21 and land use regulation, and courts, when you appeal to them, they give the expert agency a deferential standard. And so, on the other hand, you do have sort of independent judgment that you're applying. So I need to think about that, somewhere between the two.
Okay, thank you.
Thank you. Mr. Weddleton.
Thanks. I think one question was, when we talk about, can we show it's not detrimental in some ways, when we set the 200-foot separation distance, it's because we said closer than that, we have a problem. So it's like we've decided that and approved that and applied it for years now. So just by having that standard, we're saying that there's the detrimental effect, and then we can see the detrimental effect. We have separation distances, so these very different uses don't get mad at each other. They're mad at each other. So that shows there's a detrimental effect there. And anyway, so there might be a statement, not a question, but this is a question for Dean and maybe Ryan then, is the fact that AlaskaSense has asked for a variance from that separation distance from a religious assembly. The premise is they accept that there's a religious assembly there. Please give us a variance. So that's like settled. Isn't that right? That's a question.
We're not supposed to be debating.
That's a question.
Sure, you can ask a question. If you
That's a
have
question to
specific
Dean or Ryan or whoever answers that.
Sure. If it's a question to you, go ahead.
Sure. So the only reason we submitted the variance is because. Oh, I thought that was.
Well, Mr. Weddleton, who do you want to answer your question?
Whoever is most appropriate.
I mean, I can tell you why we submitted it.
Go
We
ahead.
submitted it because the incomplete letter that we got from the planning department would not process our conditional land use application unless we submitted a variance. To deem it complete, we needed to submit the variance. So I couldn't even get this in front of you. I couldn't get it in front of you until I submitted the variance.
Thank you, and I just want us to be very careful that we aren't making any arguments or debate-type statements. We need to just be asking questions. Mr. Gates, did you have something?
Yes, from what Ms. Wilson said, I do recall reading something about the sequence of events that led to the applying for variance, and that I think is in the packet that was originally submitted. So I would ask Ms. Wilson to maybe on Tuesday night point out the page number of the record from the packet, that resolution, to which that sequence and the reason that you applied for the variance reflected.
Yeah, go ahead.
I would just like to add that,
Name?
McNulty. I'll wait for the microphone. I would just like to add to the conversation about the fact that they were required to submit the application because of the completeness. There is another option. My determination could have been appealed, which would have been the appropriate thing to do within a determination. If there was a conflict in opinion about whether or not that was the correct determination.
Okay, determination that they needed a variance.
No, determination that Hope Church was a religious assembly.
Thank you. Ms. Quinn Davidson.
Do you want me to use the mic or does it matter? I can speak louder.
Yeah, that's good.
Thank you.
Hello. Hi, everyone. Thank you, Mr. Chair. So I think Meg and Dean are right. There's this initial question of whether it's a religious organization. Austin Quinn Davidson. With the variance that Mr. Weddleton, you kind of touched on it. Can someone educate me as to how the 200-foot buffer came to be and whether it matters what neighbors think? And I mean, I just wasn't around for that, so I don't know how it got started and why, how we weigh the opinions versus it being a bright line rule.
Through the chair, Ms. Quinn Davidson, this is Ryan Yell. So I'll be very brief in explaining how that came about. So initially, the separation distance was measured via shortest practical pedestrian route, which is still in play today. We did not have the rule that you had to be 200 feet lot line to lot line measured via a straight line. The reason that was put in play is to prevent a church from moving, or a marijuana establishment moving in across the street from a church, because the right-of-way dimension for a freeway is roughly 150 feet wide, 250 feet wide, so it would prevent that. I can go into further specifics if you'd like, but that is a very brief, high-level explanation of that.
And I think Mr. Constant informs me that there will be a memo that details the history that we'll get by Tuesday.
Oh, great. That would be really helpful. Okay, yeah, because I think that still doesn't really get to the heart of the question, which is, does it matter what the people think nearby? Or is this just a bright line rule that in every situation we believe as a city it's better for the public? But why? If the neighbors don't care, why do we care? So anyway, I think I just need more information on that. Thanks, Mr. Constant.
I can put you in the queue. Yeah. Mr. Constant.
Thank you. Hello, Christopher Constant here. So a few questions actually, and I did ask Mr. Gates for a memo detailing the kind of what's the nature of the power of a variance, how we implement that, what are kind of the rules, and also the history of how the church protection came into being. It was a question that was asked to me that I forwarded, and I'm looking forward to an answer to that. And I was told by Tuesday. We couldn't be here today, regrettably. So a couple of questions for the planning department under the rubric of the second question, not the first. The first being 200 feet, the second being harms. What are the harms that you imagine there? Was it loitering or drug use in the streets or dilapidated buildings? There are patrons using drugs, etc. What? Because in a universe of all possible harms, we could imagine all kinds of things. And so to follow on with what some people have said, it appears we've created an impossible standard because there's no way nobody could create no harm. I could create a harm, some would say, just by walking by. And so, that's a matter of subjective interpretation. So what are the bases on which the harms that you can't guarantee will not happen are? Then the kind of more interesting question, I think, as was handed out in one of these memos that I haven't had a chance to really read, but it raised a question right off the top. That's the Birch, Horton, Bittner, and Shrew document with their statement that it's not a church. And they quote a definition in AMC 2135.020, which is old code. And it actually uses the term church. And we have been kind of trained up to believe that religious assembly is the term that we use in the municipality because that's what the new code does. But the effective code right now is the old code for this location. And the definition of church under this section of the code reads to me exactly what they say. A building or structure, a group of buildings or structures which by design and construction are primarily intended for the conducting of organized religious services and accessory uses associated therewith. Is that an accurate definition of what a church is in the old code, Title 21 in the downtown? So that's kind of a couple questions there. And one last kind of editorial note to the folks from the Hope Center. I appreciate that in your latest communications, you've taken out a whole set of arguments that were previously made. It's noted. Thank you.
Sure. Through the chair, Ryan Stewart, Assistant Municipal Attorney. I think there was a lot there to unpack, and so I don't think I'm going to meet all of the questions that were posed by Assembly Nick Constance. But to speak to the first one I perceived, planning is not imagining harms. They're reviewing the information that's brought to them by the applicant and what information is filed with the public and otherwise publicly available as part of their review process, which is outlined in the staff memo. So I think you'll see the reasoning laid out there, and I will certainly allow Ms. McNulty and Mr. Yell to elaborate if there are additional information there that they did not capture in the staff analysis, but I think you'll find their reasoning and rationale information reviewed there in the staff pack.
As Mr. Constant, if I might, can we please just have an executive level detail of what you have in the memo, because the memo isn't here. What are the theoretical harms?
Can you clarify which memo you're saying?
So this attorney just referenced a memo that says the staff has laid out the case in which the harms are. So what I'm asking for is add into the record right here and right now what those proposed harms are so that I can understand if it's a reasonable concept or if it's in the realm of any of all possible harms, which is irrational and unachievable.
Through the chair to clarify, I was referring to the staff packet, not a staff memo. So this is the same packet that we've been referring to throughout the work session here today.
I mean, this packet.
No, this one.
Right. And so because we don't have the 300 pages of documents, you can just read from that if you have it.
So through the chair, the handout that I passed out that has the licensing review on it, if you turn the page, it's the staff packet, and that's what they've been referencing.
And it's 13G too, Chris, in our.
So now we've established this memo's in the room. Would the staff go ahead and please communicate for the record in live open session what the harms are that are contemplated? Then we'll get to the second question.
All right, through the chair, this is Ryan Yell. Kind of expanding upon what Assemblymember Weddleton touched on earlier, required separation distances are meant to provide a buffer between potentially conflicting uses. Given that the separation distance is not met in this case, there exists a regulatory reasoning that there would be adverse impacts between these two protected land uses. And I would put it on the Assembly to figure out exactly why there would be any adverse impact on that.
So then the argument is, if I understand it correctly, that just by virtue of the fact that there's the 200-foot line, that's enough evidence that there's harm, that's your case. That's your claim.
Through the chair, this is Ryan Yell. That's based upon the precedent the Assembly has set to date.
Thank you. Now the second question. The second question was under the code as it's written and stands today, Title 21.35.020 has a specific definition of church, which is not the colloquial general definition of church, and it's not the definition in all the rest of Anchorage, which is religious assembly. Instead, it's church. And the definition states that which by design and construction are primarily intended for the conducting of organized religious services and accessories use associated with therewith. So is that an accurate read of what the definition under Title 21, which is what this variance is asking to?
That is the definition under old Title 21 for a church. It is also the definition under current Title 21 for religious assemblies.
And so does the phrase, and this will be my last question, I'll hand over the mic, does the phrase which by design and construction are primarily intended for the conducting of organized religious services and accessory uses associated therewith not have meaning here?
I think what if I'm understanding your question, the question is that because they're operating out of the space within another building, is it still a primary structure? And the answer is yes. Just because there's not a standalone structure that was specifically built for a church or religious assembly doesn't mean that you can't have an existing building that has a structure or a room within it that is also holding religious assembly or meets that definition. It can still be a church. A strip mall might be a good example. We have lots of strip malls around town that were probably originally constructed as retail and are now housing religious assembly.
Mr. Gates?
Should I get a mic? Can you hear me okay? I'm sorry if I'm a little behind the dialogue. I think Ms. Saltel asked, where did the 200-foot separation distance come from? Where was it originally from? Or perhaps that was Ms. Quinn-Davidson. And I just looked up a little in slave history. In Ordinance 2016-144, as the 200-foot, as the crow flies, separation distance was enacted, adopted October 2016. And the AM attached to that has a statement that says the ordinance proposes the following amendments. In order to avoid the establishment of a marijuana business directly across the street from a protected land use, a 200-foot as the crow flies separation between marijuana establishments and protected land uses is proposed. That's all it says about that. And that was effective January 1, 2017.
Thank you. Ms. LaFrance?
Thank you, Mr. Chair. My questions have been mostly addressed by what other members have raised, and I guess I was looking at the staff analysis, especially 4B, when we were talking about granting the variance will not be detrimental to public welfare or injurious to other property in the area. In terms of what evidence did you also look at the notices of violation? I mean, just for my own clarification, that is part of this consideration as well, or not? Because I noticed we have them in our packet and I wasn't sure why. Thank you.
Through the chair, this is Ryan Young. So in the approval criteria for a conditional use permit in downtown for marijuana, violations are not explicitly stated in the approval criteria. For a marijuana establishment applying under the new code, so anywhere else in Anchorage, we can take into account violations in the planning analysis. So given that it's not explicitly stated in the approval criteria, planning did not provide any analysis of any past most violations.
Okay,
Thank you. Ms. Zalatel?
Thank you. Ms. McNulty said that she had made a use determination, and so I have a few questions around that. Was that a formal or informal use determination as to this being a religious assembly?
It was formal.
Okay, and so is there a code provision I can look at for that process that governs that?
No, we do not have a codified process.
Okay, and when that was provided to, who was it provided to?
The original conversation came from a gentleman named Mr. Ray Craig.
So I'm just trying to make sure I understand. I'm really big into process, as you know. So would you say that the use determination would be the emails then?
Sorry, I guess I have to restate my previous opinion. It would be considered informal in that they did not submit the proper form.
Okay, so there wasn't a form submitted. Is there a code provision that governs informal use determinations? And then is there, you said they would have a right to appeal. Is there, was there notice given to the person who you gave the informal use determination to about their right to appeal that determination and how to do that and the timeline in which they would need to?
No.
Okay. Is there a code provision that governs informal use determinations I can refer to?
No.
Okay. Thank you.
You say they didn't submit the form. Who would they be?
Well, whoever the applicant, anybody. But in the context of that conversation, I did note to Mr. Craig that it was clear that he was unaffiliated with the Downtown Hope Center, and had asked that they bring someone from the organization into the conversation prior to continuing any dialogue.
So is it fair to say that the informal use determination was the email with Ms. Wellsine?
No, it's the one that responded to Mr. Craig where Ms. Lori was copied.
That's correct. Okay.
And I guess I would like to add that code also doesn't have a requirement that we have to provide use determinations. So it's typically something that's done because someone either is in a situation where it's not quite clear where maybe their use falls under, or for a matter like this, but there's no requirement that we actually do formal use determinations for every use that occurs.
Can I ask one more follow-up? Thank you. Well, you said that they had the right to appeal, so I guess I'm trying to get to the crux of that is where does that right exist from and how does someone get notice of it versus maybe taking another route?
Right. And that's a great point. And we could have formalized the request if we realized that there was going to be a question about whether or not it was a church. So that wasn't asked. I think from my perspective, the lesson is learned is that in these situations, we'll follow a formal process, so there's an appeal process. But to that end, I don't think the determination would have been different. And had we known they were going to challenge it, we could have formalized it, so there would have been an appeal process.
Thank you.
Thank you. I'll add you to Mr. Peterson.
Thank you, Mr. Chairman. I just wanted to talk a little bit about separation distances and how those came about. When the voters passed initiative in 2014, it was to regulate marijuana similar to alcohol, and the 200-foot separation distance is what is required for alcohol facilities, I believe. And so originally, when the marijuana committee was talking about separation distances, we started at 200 feet. But there were some members of that committee that were pushing for 1,000 feet. And so eventually we came up to a compromise of 500 feet. And then we got into the pedestrian route, and it got extremely complicated, and that's why the 200-foot straight line distance was added in late 2016. And so that's, and then Eagle River got the 1,000-foot separation distances that the members from that part of town were hoping for. And so that's sort of how we got to where we have the current separation distances. Thank you.
Thank you.
Mr. Constant.
Thank you. So, stuck on this idea of the definition. I have to find the right place in the packet for the definition of religious assembly versus the definition of a church. Because, in fact, in the code, they're different, substantially different. So, what I understand is the definition of the church I've already read, which is constructed for the purpose. And in the new code, it reads, religious assembly is defined as a building or structure, a group of buildings or structures intended primarily for the conducting of organized religious services, as opposed to constructed for. And so I might be reading a very technical level of kind of cutting of the onion, but it seems like we have a difference in the code. Can you describe to me your difference, the definition of the code in those two similar but different sections?
Sure. While planning is working, Mr. Gates.
Thank you. I think that what I'm going to say is relevant, but not about how they interpret the definitions, but it is which definition is applicable. That was one of the questions I had as well. And researching this old new Title 21 for the downtown districts says that old Title 21 will apply to downtown districts B2A, B2B, B2C. This is B2B. So all of old Title 21 is supposed to apply, including the definitions. However, the marijuana establishment regulations, they were added after new Title 21 was adopted with that language. And marijuana establishments, they weren't in our code at all, old or new, until after new Title 21 was adopted. Old Title 21 was amended with the word religious assemblies at the same time. New Title 21 was amended with marijuana establishment provisions with religious assemblies. So one maxim of statutory construction is what did the legislative branch mean? They adopted it. They adopted old code for marijuana establishments at the same time. They adopted new code for marijuana establishments using the term religious assemblies in both old and new. So in some ways, I think you could interpret this mix of laws to apply either definition to old code. I'm not exactly sure which one is appropriate. However, I think it's reasonable to say the new code definition applies to this old code use because marijuana establishments were added to old code after new codes, whole new Title 21 stuff. I'm not sure if you're tracking.
Yeah.
I think to the question about the technical differences that the planning department is not prepared to speak to that today.
Sure, go ahead. Yeah, you're I just want to finish.
Thank you. This is Chris Constant again. So clearly what we hear is there's, until you come back, we don't have an opinion on what the difference is, but I can read simple language. I'm not an attorney, but that's pretty straightforward, which could be argued that that is enough of a challenge for the applicant. How would they know? Because they look at the definition and it fits, that's certainly confusion that's extraordinary to the process. So that might be an additional part of the conversation we have later, that our codes were unclear, and I understand that the applicant had to do their homework to make sure there wasn't a competing use, but the question is, if the code is not clear, then where does the kind of fracture lie?
Thank you. Mr. Dunbar.
Thank you, Forrest Dunbar. And I remember the discussion about the 500 versus 200 feet, and Mr. Weddleton used the term spheres of influence, which I remember a lot because it implied the opium wars in China in the 19th century. But I remember at the time expressing my frustration with this system in the sense that I agree with the separation distances with public uses like schools, but when you pit private uses against each other, you end up with situations exactly like this. And I remember one of the hypotheticals we used was actually about religious assemblies where folks were just meeting in an apartment building, and there was no way to know that they were doing it, but they were meeting and assembling there. And I'm trying to remember, I can't remember what the result of that discussion was, but I think it was that marijuana establishment or future establishment was not responsible for knowing that this religious group was meeting in this random apartment building that was near them. This situation is a little different because it's a different zoning district. But I want to ask a specific question to the planning department, which is about not grandfather rights exactly, but something similar to that, what Mrs. Zolotel was getting at, and I didn't quite understand the answer. So clearly, if this marijuana establishment already had their license in hand and was operating, and then this religious institution or this Hope Center decided to turn one of their rooms into a religious assembly, that would not force
the marijuana establishment to close or to leave. So at what point does that right attach for that marijuana establishment? Is it literally just a race to see who can get their license first? Or is it, we have all these preliminary steps that the marijuana establishment took, and then they placed the Downtown Hope Center on notice that they were coming in, and then the Downtown Hope Center, a number of weeks or months later, suddenly one of their rooms turned into a church. So at what point did that marijuana establishment have any rights that couldn't be trumped by that other private individual sort of racing in there?
McNulty, from the planning department's perspective, it would have been when they initiated the state application. It's a tangible guideline.
Okay. And where? All right. Thank you. I'll keep reading this.
Thank you. Mr. Whittleton. Oh, and sir, go ahead.
If I could, through the chair, respond to Mr. Dunbar's question. Just wanted to bring the body's attention to 2150-420 sub B.
Through the chair, before you go on, I'm having a real problem with this procedure because we had one economic development meeting where the planning staff got to present, we didn't get to present. We're having another situation where we're not getting to actually respond to things, so it's a one-sided conversation with the city's representation and not us. And I don't think that's very fair, and it's not going to look very good on the record if this gets appealed. So I would like to also be involved in this question and answer if this is what the format we're going to take. Because I have plenty to say on this issue as well.
So let me get legal advice, but for now I'm going to have them answer.
Thank you. Just to complete the thought, would draw your attention to sub 4 of the previously cited 2150-420 in determining whether to grant, deny, or impose conditions on the conditional use permit for a marijuana retail sales establishment. The assembly shall not take into consideration the sum paid by any person to acquire the license or prepare the establishment.
What was that? Repeat slow.
The assembly shall not take into consideration the sum paid by any person to acquire the license or prepare the establishment.
Prior work, when they're going to lease the facility, it doesn't count as starting the application. In a sense, that's what he's arguing. It has to be actual filing. So that's the question. They just told me it's when they file the application.
So I can ask that question.
So the question that comes from that statement of 21.50.420B in code, that we can't take into consideration the financial contributions made by an applicant, is the implication of that we can't consider that they had initiated an application or put anyone on notice prior to the time of the actual application submitted, even though the state requires a physical location in order to submit an application?
The two things. The two things you mentioned about not considering, I don't think, to me, fit into that sum or amounts paid in preparing the site. I think that relates more to paying that rent each month for a few years. That's what you can consider. Does that answer your question? Can you clarify?
Not yet, no. I had to think on it before, maybe someone else can.
Sure, and I just want to put it on the record, the conversation that I had with Assembly Council first.
So after discussion with Assembly Council, it is my conclusion that it's best for Tuesday for questions. But if members have questions for the applicant, they are allowed to ask them. So I'll just put that there, and so if members want to ask the applicants, you can. But back and forth will happen on Tuesday. So Mr. Dunbar.
I just have a follow-up. So thank you, Ms. McNulty, for that very clear answer. You have interpreted that, or the grandfather rights.
The rights, this is Forrest Dunbar, the rights attach when they submit the state application. Did we, and I don't have a encyclopedic knowledge of the code, is there somewhere in the code that directs you that that has to be the standard? Okay. Can you give us a citation for that?
And did you say yes? I can tell what all that was.
We have that on the record.
Okay.
Mr. Webb.
I'm backing up a bit in our conversation here, but I think as far as appeals of a director's decision, there is a Title 21 process.
Correct.
The director's opinions can be appealed from Chapter 2 or something like that. Is that right? It is
correct.
very clear that your decisions can be appealed.
That's correct.
Through the chair, Mr. Dunbar, Ryan Yell, so this is the code citation that establishes or mentions the initiation of a state Alaska marijuana license application, and that would be my apologies, I don't have an old code, Title 21 before me, but I do have new code, Title 21, and I can read that code citation.
Was it all marijuana?
It's the same language. It's just the code citation. It is the same language. So the code citation in new code is 21, Chapter 21, or Title 21, Chapter 5, subsection 055A2A.
Can you? What does it say?
So the exact line that we are discussing is applicants who have initiated a state of Alaska marijuana license on or before January 1st, 2017 are exempt from this provision.
So what I'm asking is, what part of code requires you to say that grandfather rights don't, grandfather's the wrong term, but that their rights to not be pushed out attach at the moment they file as opposed to some moment earlier than that? What's the code that requires you to have that standard?
Okay, sorry, there's no exact code for that.
Thanks.
McNulty, there's no code for that. From my standpoint, it's just rationale that, like I said, it's a tangible point. We can't get into civil matters that someone has told another person they're going to bring a use in. From our perspective, it has to be something that's been initiated to show a clear demonstration that they're going to use specific use. Otherwise, it's hearsay.
Sure. Yeah, Mr. Gates.
I think that what Ms. McNulty said makes sense as the rationality. I think it's based on a history of case law on the subject of land use, and that's how grandfathered rights are sort of summed up. A history of case law that establishes legal rights, and if the government interferes through taking legal rights, it's a taking sort of issue in some ways. So she can't point to code, and I couldn't either. It's the jurisprudence of this topic.
Thank you. Did you have a follow-up?
I want to hear what the applicant has to say.
Yeah, and actually, I think Mr. Constant was going to ask some questions.
Yes, I see a hand jumping up and down, and I would like to hear the applicant's perspective on the question.
Sure. So how the code, there is no code citation for that. And basically, what I think that the intent is Jana Weltzine, for the record, thank you, is whether or not they've invested and they moved forward this project. So on May 4th, 2016, AlaskaSense went to the Downtown Community Council, presented and secured a 10-5 approval support vote from the Downtown Community Council. That was in May 4th, 2016. May 19th, 2016, AlaskaSense enters into a binding legal lease with the landlord, and it's effective May 4th. So it actually got backdated to May 4th to the approval date of the Downtown Community Council. And then in February 2017, yes, they initiated. By this time, they had been paying rent for almost a year. Okay. Downtown, they decided we're going to need to go back to the Downtown Community Council and make sure that everything is still good, because at that time, the Community Council had moved to a more formalized process. Before, it wasn't a formalized process, and I felt uncomfortable representing an application that I hadn't been in front of the community council for, because I wasn't the council back in 2016. So we went back to the community council. We secured the community council's support June 5th. Now, the reason why under the code it wouldn't make any sense that we would think that this would be a religious establishment is because under the old code, 2140.170B3N, and this is on page 4 of the packet I gave you, all of you, the big packet. It says churches under the B2C zoning, which is where the downtown soup kitchen is at. B2C zoning, a church cannot provide overnight accommodations. So churches to include any place of religious worship, along with their accessory uses, including without limitation, parsonages, meeting rooms, and childcare provided for persons while they're attending religious functions. Use of church buildings other than the parsonage for the purposes of housing or to provide shelter is not permitted. We looked at that code citation. We looked at that. If that was a church, it wouldn't be allowed to provide overnight housing for people that other than staff of the church. That's not the case. Additionally, we asked for the leases that were referenced between the church and the Hope Center. We didn't get that because Pastor Martin is traveling right now and he didn't have it available to us. But what Sherry did give us is 2 other agreements that are their templates, and they're use agreements. They're use agreements. So they're not a room where the church is housed. It is once a week, 2 hours a day, 2 hours a week, and it's just the use of the dining area. It's not a possession of premises. It's not a room that they only can access. It's the use of the dining area. How could that turn a building into the primary use of it being a church? There's just not any common sense way, especially when you look at code 2140.170B3N. They couldn't provide shelter there if they were a bona fide church. If their primary use was a church, they couldn't provide overnight shelter.
Thank you. I think I have some follow-ups on that, and then we're out of time. So I have 2 more, and then we're done. So, Mr. Dunbar.
So the meeting with the, I'm looking at your timeline here. You went to the Downtown Community Council before initiating the state license.
My client did with their previous council, and I provided that agenda with his handwritten notes and recollection of the 10-5 vote. I just found it buried deep into the original application. I didn't even see it until this morning, to be honest.
So it strikes me that we, I'm trying to get to debate, but you were not legally required to do that, correct?
Not at that point,
right.
But I don't believe at that point, May 2016, I'd have to check.
I'm fairly certain you don't have to go to community council before you submit to, you do?
Before we submit to the assembly, yes.
Before you submit to the state? Before you submit to the state, do you have to go to community council?
The answer is no.
Through the chair, Mr. Dunbar, the Ryan Yale Planning Department, you have to host a community meeting. We prefer that to be at the community council.
No. Before the state. We're using the state application as the point where their grandfather rights attach. And there's no legal requirement to go to a community council beforehand.
Correct.
We on this body have taken as a policy that we want marijuana establishments to always go to community council as much as possible and work with them. But I think the system that we set up here is disincentivizing them from doing that pre-work, because if they had just not gone to the community council and not told anybody they were doing this and just filed their state application, then their grandfather rights would have attached. But because they went into the community and tried to get support beforehand, they notified other private parties and then they raced to establish something that stopped them. Is that, am I mischaracterizing what happened?
No, that.
Am I? No.
Who are you asking? Okay.
All right.
Thank you. Ms. Elsa.
Thank you. For Ms. Wilson, so you obviously were aware and looked up the definition of churches. When was the timing on that for you to kind of throw up that red flag to look at it?
It was in May of, when we had our first community council meeting, the first one that I was at, so that was May 15, 2019.
Okay, so that was the first time it raised the red flag for you. And then why didn't you ask for a formal land use determination when this became an issue?
We had like 5 informal land use determinations from the department, from the planning department. We had several emails from 2017 up until as recently as, I provided them in your packet. I want to say up as recently, yes, of May 2019. So from 2017 to May of 2019, we had in writing, in emails, land use determinations saying it was not a protected use.
Did you know you could appeal an informal land use determination?
I didn't find anything in the code for that. I did look.
Thank you.
Thank you. Mr. Constance.
So we're out of time, but I wanted, as a member of the body, to just say thank you to the planning department and your staff for this difficult process. I recognize you're in the hot seat, and